Right, we are on um, video module number 79, which is down here. We just did deposit money notice. We're on seller property disclosure. And the seller property disclosure is a 10-page document. When I started, it was 4 pages. And this document is super important. It's kind of critical, the critical thing in every file, or one of the most critical things. And we're going to go through it. The purpose of this document is so the seller can comply with the real estate seller disclosure law. When my dad or grandfather was in the real estate business, the motto of real estate was buyer beware, which meant it wasn't the seller's responsibility to tell the buyer anything. If the buyer wanted to buy the house, they're an adult. They look at the house, buy it or not buy it. It's sold as is. If there's a problem, it's your problem. Why do I have to tell you all of the potential problems that I've had or maybe not have had with the house? And you don't have to buy my house if you don't want to. It's up to you. And that was the thought process. In more recent history, the past couple decades, it's seller declare, not buyer beware. The burden of everything is on the seller to disclose it. And so this is an example of the property disclosure statement that was formulated. And the reason it was probably formulated, don't quote me on this, is that when the legislation came across that the seller had the responsibility of selling a house was on the seller to disclose any problems with the house. The sellers, of course, were like, what? You're telling me that I'm liable to disclose anything that could ever be a problem with my house, and if I don't disclose that I could be held liable for it? The sellers were probably like, what if I forget? It's a house. I've lived here for 30 years. Stress, freak out. I don't even want to sell my house because what if I forgot about some component? I mean, there's 1,000 components in a house. If there's a nick on my floor in the lower level laundry room and they find out about it, am I going to get sued? And so there's, all this concern over how to even be compliant with a regulation like that. And so the state at some point probably came up with a form that said, if, okay, we get it. As long as we're going to give you a form that is a guide that's going to cover every component in your house. And as long as you answer the questions to the best of your ability, it'll help you cover everything. And it'll trigger your memory to answer yes if there's a problem with this component of the house, and no if you don't know of a problem. And so we're gonna take the responsibility of providing this to you to fill out, and then your obligation is to answer it honestly. And the law doesn't require you to, if you don't know the answer to something, it doesn't require you to find out. You don't have to do investigations and call previous owners. But if you know of something that's problematic, that's a material defect, which is defined as something that will adversely affect the value of the home, then you need to answer yes and be honest about that. And so hence we have the form. So the seller fills it out when they list the property, and the buyer's required to review it and sign it when they buy it, before they buy a property. So in this recording, we'll just do the first page, and then we'll get into the rest of it. This form is recommended and approved for, but not restricted use by realtors. Property information and seller information. Info regarding the law. Generally speaking, the law requires that before an agreement of sale is signed, the seller must make certain disclosures regarding the property to potential buyers in a form defined by the law. Residential real estate transfer is defined as a sale, exchange, installment contract, or lease with option to buy, grant, or otherwise transfer interest in the property where not less, here's important, not less than 1 and not more than 4 units are involved. So you have a 5-unit apartment building. Does the owner need to fill out a disclosure? Nope. That's right. But a 3-unit, they would. The law defines number of exceptions where they don't have to be made. Transfers result of a court order. So bankruptcy happens, maybe. I don't know if that's a good one or not. Foreclosure, maybe. Court orders a transfer. I'm not really sure what that would be. Number 2, transfers to a mortgage lender result in a buyer's default. There's a foreclosure. So it doesn't have to, the seller, somebody defaults. Transfers from a co-owner to one or more co-owners. So I have a partnership with 2 other people, and our partnership is transferring it to a partnership with 2 other people. And one of those people is a member of our partnership. Transfer is made to a spouse or direct descendant. Transfers between spouses that result from divorce. Transfers by corporation, partnership, association to shareholders, partners, or equity owners to liquidate. Transfer of a property to be demolished or converted to commercial use. Transfer of unimproved real property. So that would be, I think, land with no improvements on it. Transfers by a fiduciary during the administration of a descendant, estate, descendant? No, descendant. I don't know what descendant means. Estate, guardianship, conservatorship, or trust. So estates are exempt. So if there's an executor in an estate, they're exempt. Transfers of new construction that has never been occupied if the buyer gets the standard warranty from the builder. Building has been inspected for compliance with applicable code, certificate of occupancy, or certificate of code compliance has been issued for the dwelling. In addition to these exceptions, disclosures for condominiums and cooperatives are limited to the seller's particular unit. So in a condominium, it's just the interior of the unit. It's not the elevator shaft. Disclosures regarding common areas or facilities are not required, as those elements are addressed in the laws that govern the entire association. While the law requires certain disclosures, this statement includes disclosures beyond the basic requirements of the law in an effort to assist sellers in complying with the requirements and to assist buyers in evaluating property. Sellers who wish to see or use the basic disclosure form can find the form on the website of the Pennsylvania Real Estate Commission. So this goes way beyond the requirements, is what it's saying. Mm-hmm. This statement discloses sellers' knowledge of the condition of the property as of the date signed by seller is not a substitute for inspections or warranties the buyer may wish to obtain. The statement is not a warranty of any kind by the seller or a warranty representation by any listing broker or any selling real estate broker or their licensees. Buyers encouraged to address concerns about the condition of the property that may not be included in this statement. Statement does not relieve seller of the obligation to disclose a material defect that may not be addressed in this form. Material defect is a problem with a residential real property or any portion of it that would have significant adverse impact on the value of the property that involves an unreasonable risk to the people on the property. The fact that a structural element, system, or subsystem is at or beyond the end of its useful life is not a material defect. Check yes, no, unknown, or not applicable for each question. Be sure to check NA when a question does not apply to the property. Check unknown when the question does apply to the property, but you are unsure of the answer. Okay? So that is a summary of kind of what the form means and how to fill it out and what exemptions apply. Does that make sense? Mm-hmm. Okay. So we'll stop this recording here, and then and then at the bottom you can see the initials, and everybody's required to initial and all that stuff. Right.